So in your abuse of power, that in the summer of 2024, the indictment involving classified documents was dismissed after determining your appointment violated the Appointments Clause of the Constitution, but you continued to sign your name on court filings until the time you resigned from office in January of 2025. A federal judge just recently stated a prosecutor who continues to sign his name in court filings after a disqualification order should face disciplinary action or disbarment.
This may look like a heated exchange between a lawmaker and a former prosecutor, but it's actually a stress test for constitutional limits. What's really being tested here is whether prosecutorial power can expand without meaningful oversight. And what happens when those charged with enforcing the law operate beyond clear institutional boundaries? This raises broader questions about separation of powers, accountability, and whether legal authority in Washington is restrained by rules or driven by outcomes. In this video, we'll break down how this confrontation exposes deeper structural tensions inside the justice system, and why that matters far beyond one investigation.
Thank you very much. Thank you very much. I recognize the gentleman from Texas.
Thank you, Chairman. Mr. Smith, how many members of Congress or the Senate did you subpoena phone toll records?
As I sit here right now, I do not recall a specific number.
Is this the complete list right here? Well, let me ask you this. Am I on this list? Did you target my records and subpoena my phone toll records?
My understanding is your records were subpoenaed by prosecutors before I became special counsel.
Well, staff would put this up on the screen. I'm thankful for the great staff who discovered the email where I learned for the first time a few weeks ago that my phone records were indeed targeted. We called AT&T and we've learned that they were given to the Department of Justice, as this email indicates, because I've been in communication with Scott Perry, one of my colleagues here in Congress, who literally had his phone taken from him in front of his family. And of course, as we've already talked about in this document, it talks about you could be in violation of the privilege by even obtaining and possessing this information if the member objected to the disclosure. This happened 4 years ago in May of 2022, and I couldn't object because I didn't know. I didn't know until about 3 weeks ago. My question here is, was there any limits to your investigation or the investigation that preceded you, Mr. Smith? Because as egregious as a violation of separation of powers this is, as an egregious and abuse of power it is, it's far more concerning you are clearly targeting American citizens for merely being conservative or supporting the president. We've got memos that we've already been talking about in this hearing from April 2022 that preceded you that established and opened the investigations, one of which has Attorney General Merrick Garland's signature on it. And the focus was the electors. Now, that was 6 months before you were appointed. You testified earlier, you met and interviewed Merrick Garland and Deputy AG Lisa Monaco, and you briefed the AG and Deputy multiple times. Did you brief them on the electors and the prosecution of their supposed crimes?
I'm sorry.
Did you brief them on the electors and their supposed crimes?
I don't recall specific conversations, but I'm sure that in the course of briefing them, I discussed.
Wasn't that the purpose of the entire investigation as it was set out? Because putting aside that in 1960, it was already talked about, my friend, Mr. Tiffany, that Hawaii put forward an alternate slate of electors, the investigation pivoted to President Trump and, frankly, anybody who knew him. Do you know who Cleta Mitchell is?
Yes, I do.
She's an election lawyer that was involved in filing an election contest on behalf of President Trump in Georgia in December of 2020. A 64-page complaint with over 1,100 pages of exhibits, witness affidavits, and expert witness reports documenting thousands of votes cast in violation of Georgia law, but which were nevertheless included in the vote totals. Now, notwithstanding the disposition of the cases that was filed, is that a criminal act? Filing an election contest on behalf of a candidate for office, a client. Is that a criminal act, yes or no?
No, in fact, we stated.
So why did you deem it appropriate to monitor Cleta Mitchell's long-distance phone records in 2023, 2.5 years after the election contest was filed and after the presidential electors were certified? What about Jen Ellis? What about Sidney Powell? What about Bill Sepien? What crime did you suspect had been committed by them that would warrant monitoring their phone records 2.5 years after the 2020 election was certified?
With respect to Sidney Powell, she is one of the co-conspirators alleged in the indictment. I don't know what you mean by monitoring, sir, if you're talking.
Well, there were some 400 plus Republican conservative groups and leaders who were targeted by your investigation. Their financial records were obtained, records of the RNC, the Trump campaign, Cleta Mitchell, the Conservative Partnership Institute, the America First Policy Institute, NRCC, NRSC, PACs, conservative groups, people all across the country, citizens, because we hear a lot about members of Congress. And we should, because of separation of powers and the egregious abuse of power. But what we're not talking about enough, in my opinion, are the American citizens that have been targeted. Because frankly, are there any limits to the power of a special prosecutor or special counsel? So much.
The moment it happened, the room shifted. Not with shouting, not with spectacle, but with a quiet, unmistakable realization. A sitting member of Congress learned, years after the fact, that his personal phone records had been quietly turned over to the Department of Justice. Not because he had committed a crime, not because he had been charged, but because at some point, someone decided he was close enough to the wrong people or the wrong ideas to justify it. That is the moment this hearing crystallized. Representative Chip Roy wasn't asking for hypotheticals. He wasn't speculating. He was holding up an email, a paper trail. Evidence that his communications had been swept into an investigation without his knowledge, without his consent, and without any opportunity to object. And when he asked Jack Smith a direct question, was I targeted? The answer was not a denial. It was a deflection. That answer matters. Because this wasn't about one phone record. It wasn't even about one investigation. It was about whether there are limits left in American governance or whether power, once claimed, simply expands until challenged. What unfolded in that exchange revealed something deeper than partisan conflict. It exposed a system increasingly comfortable with surveillance first and explanation later. A system where accountability seems optional, memory becomes selective, and responsibility dissolves into procedural fog. Jack Smith repeatedly said he did not recall. He did not recall numbers. He did not recall specific briefings. He did not recall conversations with the highest officials in the Department of Justice. And yet those same briefings shaped investigations that reached across Congress, across campaigns, across private citizens, long after elections had ended and certifications were complete. That contradiction sits at the heart of this moment. If an investigation has no memory, how does it justify its reach? If power cannot explain itself, how is it restrained? Representative Roy's questions cut directly to the constitutional core. Separation of powers is not a slogan. It is a safeguard. And when investigative authority quietly crosses into the legislative branch, collecting communications, financial records, and personal data without notice, it is no longer merely enforcing law. It is testing boundaries. And when those boundaries are tested in silence, the public learns too late. The hearing made clear that this reach did not stop with elected officials. Hundreds of private citizens and organizations, lawyers, advocacy groups, campaign staff, policy institutes, found themselves swept into a widening net. Not because they were charged, not because they were convicted, but because they were adjacent. Adjacent to speech, adjacent to legal challenges, adjacent to opposition. That distinction is critical. In a constitutional system, association is not guilt. Advocacy is not wrongdoing. Legal argument is not conspiracy. And yet, when investigations blur those lines, they create a chilling effect that no court ruling can fully undo. Even more troubling was the question of limits. Representative Roy asked it plainly, were there any? The record suggests that even after a federal court determined an appointment violated constitutional requirements, the machinery continued to operate. Filings continued. Authority continued to be asserted. The name continued to appear on official documents. That is not a technical oversight. That is a warning sign. Because when power continues after legitimacy is questioned, the issue is no longer partisan. It becomes institutional. It becomes moral. The response from Jack Smith attempted to narrow the issue, to confine judicial findings to specific proceedings, to rely on procedural distinctions between jurisdictions. But for the public watching, the broader concern remained unanswered. Who watches the watchers? Who tells the prosecutor to stop when the line is crossed, not in theory, but in practice? This hearing was not about defending individuals. It was about defending the idea that the American system is governed by restraint as much as authority. That power is borrowed, not owned. And that the Constitution is not self-enforcing. It depends on people willing to challenge overreach, even when it is uncomfortable. Moments like this do not resolve neatly. There is no gavel slam, no dramatic confession. What remains instead is something more enduring, a record. A question placed into history. Were we paying attention when the lines were tested? Because the erosion of liberty does not announce itself loudly. It arrives quietly, through process, through paperwork, through explanations that come years too late. And that is why this exchange matters, not just for one congressman, not just for one investigation, but for anyone who believes that power in America must answer to the people, not the other way around. If accountability fades, the system weakens. If memory fails, trust collapses. And if citizens stop questioning authority, the Constitution becomes decoration instead of defense. This is why oversight exists. This is why hearings matter, and this is why independent journalism matters. At Liberty Report USA, we believe sunlight is not optional, it is essential. If you believe these questions deserve answers, if you believe power should never operate unchecked, support our work. Subscribe to Liberty Report USA and help us continue exposing the truth.